Good afternoon, everyone, and welcome back on today's episode of the Conference of the Future of Europe. Today, we will be focusing on the extradition of EU citizens in third countries. We welcome today a master's student, Salomé Delsaux, a master in international and European law in the Catholic University of Lille.
Thank you, Julie. So today we're going to talk about some different issues that have been raised for the last few years when facing an extradition request in the EU.
So could you please enlighten us on the extradition process in the EU, please?
Of course. So first of all, let me give you a quick definition of what an extradition is. An extradition is the act of making someone return for trial in another member state, in another state in general, when they have been accused of doing something illegal. In the EU, there is a really great tool that has been put into place. It's the European arrest warrant. And it has been set up by a framework that has been in force since the 1st of January 2004 in all member states, and it allows countries to request and approve a cross-border transfer of a requested person without the need for political involvement. So this tool has helped to make the procedure way more straightforward and faster, but it does not stop some issues to actually happen.
All right, thank you for this introduction. Could you now tell us what are the current issues related to the extradition of an EU citizen to a third state?
So in terms of these different issues, in December 2020, Eurojust and the European Judicial Network published a joint report which was requested by the Council on practical experiences with the extradition of EU citizens to third countries. This report confirmed that the application of the case law has actually been raising several practical and legal issues. So let me give you a bit of context. So in 2016, in the Petroin judgment, the CJEU introduced specific obligations for member states to extradite EU citizens to a third state. There is a need of a specific consultation procedure. And it gives the opportunity to prosecute the citizen by means of a European arrest warrant.
All right, then how did the Petroin judgment influence the following case, and what are the legal issues that are still arising?
So the approach of the case Petroin was confirmed, and to a certain extent was quite precise in the following case law. But the application of this case law has proved some difficulties in practice, such as in the case, the German case BY in 2020. So this case was actually a preliminary ruling that was referred to the CJEU. And the judges needed some clarification on how to apply the obligation, such as the consultation procedure, and on interpretation of Article 18 and 21 of the TFEU, which deals with the principle of non-discrimination on grounds of nationality and on the right to reside and move freely within the territory of the European Union. So, although the judgment of Petroin gave some highlights on how to apply these different obligations, when a member state is confronted to the extradition of an EU citizen to a first state, some questions are still arising. The proof is those different preliminary rulings that have been sent to the CJEU. And I'll give you now some example of what kind of uncertainties which were noticed. So, the CJEU case law does not specify at what moment a member state that has received an extradition request from a third country against an EU citizen should inform the member states of nationality. And another one is that the obligation to inform the member state of nationality of the extradition request only applies if the requested EU member state prohibits the extradition of its own nationals. The issue here is that some member states have signed different bilateral treaties and they have different approaches to extradition requests for the purpose of prosecution. Then the need of a consultation procedure, which was confirmed is in the case Petroin, has been applied in the case that followed. But as I said before, there are still some uncertainties. Some member states find that it's really unclear on how to apply it. So lots of questions have been sent to the CJEU. And on a more global perspective, a way more global perspective, when looking at the notion of extradition in between the different member states of the EU, when you don't even consider a third state, there are also issues, such as in 2022 in the case XY, where the Polish court asked for the extradition of 2 Polish nationals from the Netherlands. But the issue there was that for the Amsterdam court, it could be a breach of the fundamental rights to have a fair trial. As you may know, there are some problems of the independence of the judiciary in Poland. So questions were asked to the CJEU, which said that there's a need of highly exceptional circumstances for a European arrest warrant to be declined. So the thing is, when you see that there are some unclarity within the member state of the European Union, obviously there's going to be lots of problems in terms of harmonization in between a member state and a third state. So for the principle of mutual recognition to apply properly, there is a need of there's a need for the European Union to put into place more precise legal sources. But I have to say that there's a clear willingness of the CJEU to answer the current problematics and to create a sort of EU extradition law for the member state to be able to apply the previous principle I just told you.
Well, thank you very much for having us today. I'm really glad. It's a really interesting topic. And we will see each other on the next episode. Have a nice day.